Like and subscribe for more content.
Negotiation, mediation, and arbitration represent alternative dispute resolution (ADR) methods, offering alternatives to costly and time-consuming litigation. Each method possesses unique characteristics, advantages, and disadvantages, making the selection of the appropriate method crucial to achieving a favorable outcome. Understanding these nuances is essential for anyone facing a legal dispute. Negotiation, the most informal of these methods, involves direct communication between the disputing parties to reach a mutually agreeable solution. It requires a willingness from all parties to compromise and find common ground. The process is typically less structured than mediation or arbitration, allowing for greater flexibility in approaching the issues at hand. A successful negotiation often hinges on effective communication, empathy, and a clear understanding of each party's interests and priorities. Parties might choose to negotiate directly, or they may utilize representatives, such as lawyers, to assist in the process. The representatives can provide guidance, strategize approaches, and help ensure that the negotiation proceeds smoothly and productively. However, even with representation, a successful negotiation requires a collaborative spirit and a commitment from both sides to reach a resolution. One of the significant advantages of negotiation is its cost-effectiveness. Unlike litigation, which can involve substantial legal fees and court costs, negotiation avoids these expenses. Furthermore, the informal nature of negotiation allows for greater control over the process and outcome. Parties retain autonomy in determining the terms of the settlement, resulting in a solution that is potentially more satisfying than one imposed by a court or arbitrator. The flexibility inherent in negotiation also allows for creative solutions that may not be possible within the confines of a formal legal proceeding. For example, in a commercial dispute, parties might negotiate a mutually beneficial arrangement that involves continuing their business relationship rather than a simple monetary settlement. This preserves ongoing business interests that a court judgment might inadvertently damage. However, negotiation is not without its limitations. Its success depends heavily on the willingness of all parties to engage in good faith and compromise. If one party is unwilling to negotiate or is entrenched in its position, the process may fail to yield a resolution. Furthermore, the lack of a neutral third party can create an imbalance of power, particularly if one party possesses significantly more bargaining power than the other. This power imbalance could lead to an unfair or unsatisfactory outcome for the weaker party. For instance, a small business negotiating with a large corporation may find itself at a disadvantage due to the corporation's superior resources and negotiating expertise. The absence of a structured process can also lead to protracted negotiations, potentially delaying resolution and adding unforeseen costs. Mediation offers a more structured approach to dispute resolution than negotiation, introducing a neutral third party, the mediator, to facilitate communication and guide the parties towards a mutually acceptable agreement. The mediator does not decide the outcome of the dispute. Rather, they act as a facilitator, helping the parties identify common interests, clarify misunderstandings, and explore potential solutions. Mediation emphasizes communication and collaboration, encouraging parties to find creative solutions that address their underlying needs and concerns. A key advantage of mediation is its confidentiality. Unlike court proceedings, which are generally public, mediation is typically confidential, protecting the parties' privacy and preventing sensitive information from becoming public knowledge. This confidentiality can be particularly important in disputes involving personal or business relationships, where protecting reputation is a significant concern. Further, mediation is often faster and less expensive than litigation. The streamlined process and avoidance of court costs significantly reduce the financial burden on the parties. The collaborative nature of mediation often leads to more durable solutions, as the parties are more invested in the outcome because they actively participated in shaping the agreement. In family law disputes, for example, mediation allows parents to craft solutions that best meet their children's needs while considering their own circumstances. This personalized approach can be far more effective than a judge-imposed decision. However, mediation is not suitable for all types of disputes. It requires the willing participation of all parties. If one party is unwilling to cooperate or engage in good faith, the mediation process may be unsuccessful. Also, the lack of a binding decision can be a drawback. While the mediator can guide the parties, they cannot impose a solution. If the parties are unable to reach an agreement, they will need to pursue other means of resolution, such as arbitration or litigation. The mediator also lacks the authority to compel the production of evidence or to enforce any agreement reached. This limits the mediator's ability to address disputes involving complex factual or legal issues. Arbitration, a more formal method than negotiation and mediation, involves a neutral third party, the arbitrator, who hears evidence and makes a binding decision. The process is generally more structured than mediation, resembling a simplified court proceeding. Parties present their cases to the arbitrator, who then issues a final and binding award. Arbitration can be binding or non-binding, depending on the agreement of the parties. In binding arbitration, the arbitrator's decision is legally enforceable, while in non-binding arbitration, the decision is merely advisory and can be appealed to a court. One major advantage of arbitration is its efficiency. The process is often faster and less expensive than litigation, as it avoids the complexities and delays associated with court proceedings. Arbitration offers greater flexibility in choosing the arbitrator and the procedures to be followed, allowing parties to select an arbitrator with expertise in the relevant field. This expertise can lead to more informed and accurate decisions, especially in cases involving complex technical or specialized issues. For example, in a construction dispute, the parties might choose an arbitrator with extensive experience in construction law and practices. The arbitrator's specialized knowledge would likely lead to a more efficient and accurate resolution than a court proceeding where the judge might lack such specialized knowledge. Arbitration also offers greater privacy than litigation, as the proceedings are typically confidential. However, arbitration also has limitations. The cost of arbitration can still be significant, particularly if the dispute involves complex issues or numerous witnesses. The arbitrator's decision is final and binding, meaning that there are limited avenues for appeal. This finality can be a disadvantage if the arbitrator makes a mistake or if the process is unfair. Furthermore, the lack of public accountability inherent in arbitration can be a concern, especially if the arbitrator is perceived to be biased or unfair. The lack of discoverable evidence in arbitration may also limit the ability of parties to present a fully developed case. This can be a particularly significant issue in disputes involving complex issues where extensive discovery is necessary to fully develop the facts. In conclusion, the choice of dispute resolution method depends on the specific circumstances of the dispute, considering the nature of the dispute, the relationship between the parties, the desired outcome, and the resources available. Negotiation offers an informal and cost-effective approach suitable for relatively simple disputes with cooperative parties. Mediation provides a structured and confidential process suitable for disputes requiring collaboration and a mutually agreeable solution. Arbitration offers a more formal and efficient process for complex disputes requiring a binding decision. Understanding the strengths and weaknesses of each method enables individuals to choose the most appropriate approach to resolving their legal disputes effectively and efficiently, minimizing costs and maximizing the chances of a favorable outcome. Understanding the intricacies of the U.S. court system is crucial for anyone contemplating legal action or facing a lawsuit. The system, while seemingly complex, operates on a foundational principle of due process, ensuring fairness and equal opportunity for all parties involved. Navigating this system effectively requires understanding its structure, procedures, and the roles of various legal professionals. The U.S. court system operates on a federal and state level, creating a dual system of justice. The federal courts address matters of federal law, such as constitutional rights violations, interstate disputes, and federal crimes. The state courts handle matters of state law, including most criminal cases, contract disputes, family law issues, and property disputes. This dual system necessitates careful consideration of jurisdiction. the authority of a court to hear and decide a particular case. A case must be filed in a court with proper jurisdiction over both the subject matter of the dispute and the parties involved. Federal courts are structured hierarchically. At the bottom are the district courts, serving as trial courts where cases are initially heard. These courts are courts of original jurisdiction, meaning they are the first courts to hear evidence and determine the facts of a case. Each state has at least one district court, and some larger states have multiple districts. Above the district courts are the circuit courts of appeal, also known as appellate courts. These courts review decisions made by district courts within their respective circuits. Appellate courts do not retry cases. Instead, they review the record of the trial court for errors of law. At the apex of the federal court system is the Supreme Court of the United States, the highest court in the land. The Supreme Court primarily hears appeals from the circuit courts, and its decisions are binding on all other federal and state courts. The Supreme Court's decisions shape the interpretation of laws and establish precedents that guide future legal proceedings. It's crucial to understand that the Supreme Court does not hear every appeal. It selects cases it deems to be of significant national importance or those presenting conflicting opinions among lower courts. The state court systems mirror the federal structure, albeit with variations among states. Most states have a trial court of general jurisdiction, often called a superior court or circuit court, which hears a broad range of cases. Above the trial courts are intermediate appellate courts, and at the highest level, the state's Supreme Court. The structure and names of these courts differ from state to state, underscoring the importance of understanding the specific court structure within the relevant jurisdiction. Further complicating the jurisdictional landscape are specialized courts, such as family courts, probate courts, and bankruptcy courts, each possessing jurisdiction over specific types of cases. Filing a lawsuit involves a series of procedural steps, starting with the drafting and filing of a complaint, a formal document that outlines the plaintiff's claims against the defendant. The complaint must clearly state the facts of the case, the legal claims being asserted, and the relief sought. Once the complaint is filed with the appropriate court, the court clerk issues a summons, a formal notification to the defendant requiring them to respond to the complaint within a specified time. The defendant's response takes the form of an answer, which can admit or deny the allegations in the complaint and may include affirmative defenses or counterclaims. This initial pleading stage establishes the parameters of the legal dispute. Following the pleading stage, the parties engage in discovery, a crucial phase where information relevant to the case is exchanged. Discovery tools include interrogatories, written questions, depositions, oral testimony under oath, requests for production of documents, and requests for admission, requests for the opposing party to admit or deny specific facts. Discovery serves to gather evidence, clarify the issues in dispute, and narrow the scope of the trial. This phase is often lengthy and contentious, as parties seek to uncover evidence favorable to their case and challenge the evidence presented by the opposing side. Effective discovery requires skilled legal representation to ensure compliance with procedural rules, protect privileged information, and avoid unnecessary delays or expenses. After discovery, the parties may participate in various pretrial motions, such as motions to dismiss, motions for summary judgment, and motions in limine. These motions address procedural or evidentiary issues and can significantly influence the trajectory of the case. A motion to dismiss challenges the sufficiency of the plaintiff's complaint, arguing that it fails to state a valid legal claim. A motion for summary judgment asks the court to decide the case without a trial, arguing that there are no genuine issues of material fact in dispute. Motions in limine seek to exclude certain evidence from being presented at trial. The resolution of these motions can substantially affect the scope and outcome of the case. If the case proceeds to trial, both sides present their evidence to a judge or jury. The trial involves the examination and cross-examination of witnesses, the introduction of exhibits, and closing arguments by the attorneys. The judge instructs the jury on the applicable law, and the jury, if present, renders a verdict. If the case is tried before a judge without a jury, a bench trial, the judge renders a decision. Following the verdict, the losing party may have the option to appeal the decision to a higher court. The appellate court reviews the record of the trial court for errors of law, and the process can involve multiple layers of appeals before a final decision is reached. Throughout the legal process, individuals are typically represented by attorneys. Attorneys play a critical role in advising clients on legal strategies, drafting pleadings, conducting discovery, participating in pre-trial motions, representing clients at trial, and handling appeals. The attorney-client relationship is founded on trust and confidentiality, with attorneys bound by ethical rules to protect their clients' interests. Choosing an experienced and competent attorney is essential for navigating the complex legal system and increasing the likelihood of a favorable outcome. The attorney's expertise in legal procedure, evidence, and court procedure is indispensable in maximizing a client's chances of success. The cost of litigation can be substantial, encompassing attorney fees, court costs, expert witness fees, and other expenses. This financial burden can be prohibitive for many individuals, highlighting the importance of alternative dispute resolution methods discussed earlier. However, even with alternative dispute resolution, understanding the court system and its procedures remains vital, providing a framework for navigating legal disputes and protecting one's rights. Even if a dispute is ultimately resolved outside of court, the knowledge gained by understanding this system equips individuals to negotiate more effectively and to make informed decisions regarding their legal options. The complexities inherent in the U.S. legal system underscores the value of legal representation, particularly when the potential consequences of a legal dispute are significant. A skilled attorney not only guides their client through procedural intricacies, but also helps manage the costs and risks associated with legal action. The pursuit of justice often necessitates understanding the rules of the game, and knowledge of the court system is a critical asset in this endeavor. Navigating the complexities of the U.S. legal system can be daunting, particularly when facing a legal dispute. While understanding the court system's structure and procedures is a critical first step, equally important is knowing how to access the necessary legal assistance and resources. This is especially true given the often substantial costs associated with litigation and the inherent difficulty in understanding legal jargon and procedures. Fortunately, numerous avenues exist for individuals seeking affordable or free legal help. One of the most significant resources is the network of legal aid organizations across the country. These nonprofit organizations provide legal services to low-income individuals who cannot afford to hire private attorneys. Legal aid societies are typically funded through a combination of government grants, private donations, and fundraising efforts. They offer a range of services, from advice and counseling to full representation in court. The types of cases handled vary, but often include family law matters such as divorce, child custody, and domestic violence, housing issues like eviction and landlord-tenant disputes, public benefits cases involving welfare, Medicaid, and Social Security, and employment law issues such as discrimination and wrongful termination. To locate your nearest legal aid organization, you can perform an online search using keywords such as legal aid, legal services, or the name of your state or city, followed by legal aid. Many legal aid websites offer online case screening tools to determine eligibility for their services. Remember that eligibility criteria often involve income restrictions and the nature of the legal problem. Beyond legal aid societies, many lawyers and law firms participate in pro bono programs, offering their services free of charge to individuals who cannot afford representation. Pro bono work stems from the ethical responsibility of lawyers to provide community service and aid those less fortunate. These opportunities may vary depending on the lawyer's area of expertise and the availability of pro bono slots. While not all law firms offer extensive pro bono programs, contacting the firm directly or exploring their website may reveal any opportunities. Many bar associations also maintain lists of attorneys participating in pro bono programs. These lists often categorize attorneys by practice area, enabling you to connect with someone knowledgeable in your specific legal issue. These pro bono services often focus on cases deemed to be of public interest or cases involving civil rights violations. Access to pro bono assistance is typically granted based on demonstrated financial need, so be prepared to provide income documentation. Several other resources can provide invaluable support in navigating legal challenges. Law school clinics, run by law schools across the country, offer students the chance to gain practical experience by providing legal services under the supervision of experienced professors. These clinics often specialize in specific areas of law, such as immigration, family law, or consumer rights, and can be a valuable source of assistance for individuals with limited financial means. Their services are usually offered at a reduced rate compared to private attorneys, or even for free, depending on your demonstrated need. Similarly, many universities and colleges have legal aid centers that provide legal services to students and often extend their services to the broader community. Finding these resources often requires a direct inquiry with the institution's legal department or student services. In addition to dedicated legal assistance programs, many government agencies offer legal information and guidance. Local bar associations, often found at the county or state level, are a treasure trove of information. They frequently provide referrals to lawyers, offer educational materials on legal topics, and sometimes host clinics with attorneys offering free consultations. Your state's Attorney General's office also offers valuable resources. Many AG's offices have websites with detailed information on various legal topics and may even offer assistance with consumer protection issues, landlord-tenant disputes, or specific rights violations. Federal agencies like the Equal Employment Opportunity Commission, EEOC, which deals with employment discrimination, and the Federal Trade Commission, FTC, which handles consumer protection issues, offer crucial information and resources, often through their websites, and can even assist in filing complaints. Before seeking legal assistance, it's important to assess your need for legal representation. While some legal issues can be resolved independently using online legal guides or templates, complex matters or those with high stakes often require the expertise of a skilled attorney. Factors to consider include the complexity of the legal issue, the potential financial consequences, and the likelihood of success without legal representation. If you are facing a criminal charge, the necessity of legal counsel is paramount, given the potential consequences of a conviction. Similarly, if a lawsuit involves significant financial implications, engaging legal counsel is crucial to protect your interests and ensure the best possible outcome. In cases involving significant property, complex contractual agreements, or family matters with significant disputes, seeking professional assistance is often essential. Choosing the right lawyer is a critical step in resolving a legal dispute. Start by seeking referrals from trusted sources such as friends, family members, or other professionals. Review online attorney directories, such as those offered by your state bar association, to check credentials, experience, and client reviews. It's important to check for disciplinary actions or sanctions taken against the attorney by their governing bar association. Don't hesitate to schedule consultations with multiple attorneys to compare their experience, fees, and approach to your case. During these consultations, be clear about your legal issue and assess whether the attorney understands your needs and communicates effectively. Be sure to inquire about their fee structure, payment plans, and the likely timeline for resolving your case. An attorney should clearly explain the process and potential outcomes and ensure your understanding throughout. Once you've chosen an attorney, establishing a clear communication channel is paramount. Regularly communicate updates, concerns, and questions to ensure your attorney remains fully informed and effectively advocates for your interests. A strong attorney-client relationship is founded on trust and open communication, which is critical in navigating the often stressful process of legal proceedings. Remember to review all legal documents thoroughly before signing them, and seek clarification on anything unclear. Legal language can be complex, and understanding your legal documents is vital in ensuring you are fully aware of your rights and responsibilities. Finally, remember that seeking legal help isn't a sign of weakness, but rather a proactive step towards protecting your rights and achieving a just outcome. The resources available, from legal aid organizations to pro bono programs, government agencies, and private attorneys, demonstrate a commitment to ensuring access to justice for all. By understanding the available resources and taking the initiative to seek the appropriate legal assistance, you can navigate complex legal challenges with confidence and increase your chances of a favorable outcome. The journey through the legal system may be challenging, but understanding the resources and utilizing them effectively significantly improves the prospects of a positive resolution. Small Claims Court offers a straightforward and relatively inexpensive way to resolve minor legal disputes without the complexities and costs associated with traditional court proceedings. Its accessibility makes it a valuable tool for individuals and small businesses seeking to recover relatively small sums of money or settle minor disagreements. However, understanding its limitations and procedures is crucial for successful navigation. The primary advantage of Small Claims Court lies in its simplicity. The rules of evidence are less stringent than in higher courts, meaning you aren't burdened by the same level of formal procedures and paperwork. This makes it easier to present your case, even without legal representation. Furthermore, the costs are significantly lower than in other courts. Filing fees are typically modest, and you are not obligated to hire a lawyer, though many choose to do so for added guidance. The informal nature of proceedings often allows for quicker resolution, reducing the time and stress involved in lengthy litigation. Finally, the process is designed to be user-friendly, making it accessible to those unfamiliar with legal processes. Many jurisdictions provide helpful pamphlets and online resources guiding individuals through each step. However, Small Claims Court is not without its limitations. The most significant restriction is the monetary limit on claims. This limit varies by state and even by county within a state. You will need to research the specific jurisdictional limit before proceeding, as attempting to file a claim exceeding that limit will result in dismissal. Additionally, the types of cases accepted in Small Claims Court are generally limited to civil matters, typically involving monetary disputes. Cases involving complex legal issues, such as those requiring extensive legal research or expert testimony, are generally not suitable for Small Claims Court. Likewise, claims against corporations or other large entities may be better suited for a higher court, even if the monetary amount falls within the small claims limit. The court's jurisdiction is limited geographically, typically to the county or district where the defendant resides or where the dispute occurred. Before filing a claim, it's imperative to gather all relevant documentation and evidence supporting your case. This might include contracts, receipts, photographs, emails, witness statements, and any other materials that substantiate your claim. Organize your evidence meticulously, ensuring clarity and easy accessibility. This preparation is crucial for presenting a strong and persuasive case to the judge. Additionally, consider attempting to resolve the dispute informally through negotiation or mediation before resorting to legal action. Many small claims disputes stem from misunderstandings, which can often be resolved amicably without court intervention, potentially saving both time and expense. If you're unsure about the strength of your case, or if the other party is unwilling to negotiate, it's advisable to seek guidance from legal aid organizations, a private attorney, or a law school clinic. Many offer free or low-cost consultations, which can help determine the best course of action. The process of filing a claim typically begins with obtaining the necessary forms from the Small Claims Court clerk's office or the court's website. The forms usually require detailed information about both the plaintiff, you, and the defendant, the person or entity you are suing, the nature of the dispute, the amount of damages claimed, and the evidence supporting your claim. Complete these forms accurately and thoroughly, providing all necessary information to avoid delays or dismissal. Be sure to retain copies of all filed documents for your own records. After filing, you will receive a notice scheduling the hearing. The court will send a copy of the complaint to the defendant, informing them of the claim and the date of the hearing. Failing to correctly serve the defendant is a common reason for cases to be dismissed. The small claims court hearing is usually informal, conducted without a jury. The judge will hear evidence and arguments from both sides, asking questions to clarify issues. Present your case clearly and concisely, sticking to the facts and avoiding unnecessary arguments. Using visual aids, such as photographs or documents, can be helpful in supporting your claims. Be prepared to answer questions from the judge and the opposing party. It's crucial to maintain composure and professionalism throughout the hearing, even if the opposing party becomes confrontational or disruptive. Courteous and respectful behavior helps present you in a positive light to the judge. The judge will render a decision at the conclusion of the hearing or shortly thereafter. The decision is legally binding, and the defendant is typically ordered to pay the amount of the judgment, plus any court costs. Enforcement of the judgment is a crucial aspect to consider. If the defendant fails to pay, the court will provide mechanisms for collecting the judgment. These mechanisms can include wage garnishment, bank levies, and property liens. The effectiveness of these enforcement mechanisms varies by state and the defendant's financial circumstances. If you are successful in obtaining a judgment but have difficulty collecting it, you may need to seek additional legal assistance to pursue the available collection methods. Understanding the specific rules and regulations of your local small claims court is paramount. These rules can vary from jurisdiction to jurisdiction, affecting aspects such as filing fees, claim limits, and procedural requirements. Consulting the court's website or contacting the clerk's office directly is advisable to ensure you comply with all necessary regulations. Many courts provide helpful guides, brochures, or online resources designed to walk you through the process, answering common questions and explaining procedural requirements. Utilizing these resources significantly increases your chances of successfully navigating the small claims process. Before initiating a small claims action, it's essential to weigh the potential costs and benefits carefully. While the court offers a relatively inexpensive option, remember that even minor expenses add up. Consider filing fees, potential witness fees, if applicable, and the time and effort invested in gathering evidence and preparing for the hearing. These costs should be compared against the potential recovery to determine if pursuing the case is economically sound. If your claim is for a relatively small amount, the time and effort might not be worthwhile if the court fees or the effort of collecting the judgment significantly reduce the actual value of any possible recovery. A realistic assessment is crucial before proceeding. It's always best to start with the less expensive route, that of informal negotiation, before escalating to formal legal action. Many potential disputes can be resolved more easily, more quickly, and more efficiently through amicable negotiation and agreement. A well-written demand letter laying out your case and your desire for a resolution can sometimes be enough to settle the matter without the need for the formal expense of going to court. In summary, small claims court offers a valuable and accessible avenue for resolving minor legal disputes. Its simplicity, relatively low cost, and informal procedures make it a viable option for individuals and small businesses seeking to recover monetary damages or settle disagreements. However, its limitations regarding monetary amounts, case types, and jurisdictional boundaries must be considered. Through careful preparation, understanding of the procedures, and diligent adherence to the court's rules, individuals can effectively utilize small claims court to achieve a just and efficient resolution to their disputes. Remember that even though the court process itself is simpler than other court systems, careful preparation and understanding are still crucial. The key is to accurately and thoroughly prepare your evidence, ensure proper service of the complaint, and present your case clearly and persuasively. Proactive measures are often the most effective way to manage legal risks. Understanding your legal rights and responsibilities, coupled with sound financial practices and careful contract review, can significantly reduce the likelihood of facing costly and time-consuming legal disputes. This proactive approach is far more efficient and less stressful than reacting to a problem after it has arisen. One of the most common areas where legal problems arise is in contractual agreements. Whether it's a lease agreement for your apartment, a contract for the purchase of goods or services, or an employment contract, understanding the terms and conditions is crucial. Before signing any contract, take the time to carefully read and understand every clause. Don't hesitate to seek clarification from the other party or consult with an attorney if anything is unclear or seems unfavorable. Pay particular attention to clauses dealing with payment terms, deadlines, liabilities, and dispute resolution mechanisms. A poorly drafted or misunderstood contract can lead to significant legal battles and financial losses. Ensure the contract accurately reflects the agreed-upon terms, and if there are any deviations from what you initially understood, address them immediately before signing. If you have any reservations, it is always advisable to seek independent legal counsel to ensure your interests are protected. Maintaining good financial practices is another critical aspect of protecting yourself from legal pitfalls. This involves keeping accurate records of all financial transactions, including income, expenses, and debts. This meticulous record keeping can prove invaluable in the event of a dispute, whether it's with the IRS, a creditor, or a business partner. Accurate financial records provide concrete evidence to support your claims and refute any opposing arguments. In addition to accurate record keeping, adhere to responsible borrowing and credit management practices. Avoid accumulating excessive debt and always pay your bills on time to avoid negative impacts on your credit score and potential legal action. Understanding your credit report and proactively addressing any inaccuracies is also essential. A healthy credit profile significantly reduces the risk of legal challenges arising from financial mismanagement. Furthermore, familiarize yourself with relevant consumer protection laws in your state and jurisdiction. These laws provide safeguards against unfair or deceptive business practices, and understanding them can empower you to navigate financial transactions more confidently and protect yourself from potential legal issues. Understanding your rights and responsibilities as a citizen is paramount to avoiding legal problems. This encompasses a broad range of areas, including employment law, consumer protection law, landlord-tenant law, and traffic law, among others. Familiarizing yourself with the relevant laws pertaining to your daily life can prevent misunderstandings, disputes, and potential legal actions. For instance, understanding your rights as an employee, including those regarding wages, working conditions, and discrimination, can help avoid employment disputes. Similarly, understanding consumer protection laws allows you to protect yourself from unfair or deceptive business practices. Knowledge of landlord-tenant law can help prevent disputes with your landlord, while understanding traffic laws ensures you avoid legal repercussions for traffic violations. In many instances, a simple understanding of the law can avert potential legal problems altogether. For areas of the law you are not familiar with, consider seeking legal guidance to gain a better understanding of your rights and obligations. For example, if you anticipate entering into a complex business deal, the investment of seeking legal guidance to establish a solid framework prior to entering into any agreement can save you considerable amounts of money and stress further down the line. Protecting your personal information is equally crucial in today's digital age. Identity theft and online fraud are significant threats, and taking steps to protect your sensitive information is vital. Use strong passwords, regularly update your software, and be cautious when sharing your personal information online. Consider using credit monitoring services to help detect any suspicious activity on your accounts. Being vigilant about your online security can prevent significant legal and financial problems. In the event of identity theft, acting swiftly and reporting the crime to the appropriate authorities is crucial to mitigate further damage. Furthermore, it is important to monitor your credit report closely and report any inaccuracies or suspicious activity to the credit bureaus promptly. Proactive measures to prevent and address such issues significantly reduce the risk of severe legal complications. Beyond these individual precautions, building a strong network of trusted advisors can provide invaluable support in navigating legal challenges. This network may include an attorney, an accountant, a financial advisor, and other professionals who can provide guidance and support when needed. Having these trusted advisors available allows for proactive consultation and advice before situations escalate into legal disputes. Regular consultation with these professionals can help prevent issues from arising in the first place and allows for early detection and effective management of any potential problems. This proactive approach to managing legal risk is not only more efficient, but can also significantly reduce the financial and emotional toll associated with resolving legal disputes. The cost of a consultation with these professional individuals is often a minimal price to pay to prevent more serious and potentially costly problems later. It's also important to remember that prevention is always better than cure. While having a strong legal network and understanding your rights are crucial, proactively seeking legal advice before embarking on potentially risky ventures can often prevent legal complications from arising in the first place. Whether it involves business dealings, property transactions, or complex personal matters, seeking professional advice before committing can often identify potential legal pitfalls early on and allow for the implementation of mitigating measures. This preventative approach not only saves significant time and resources in the long run, but also helps foster a sense of peace of mind and confidence when navigating potentially challenging situations. The cost of a consultation up front is often a fraction of the cost of resolving a dispute that could have been prevented. In conclusion, protecting yourself from legal pitfalls involves a multifaceted approach, combining proactive measures, responsible financial management, a thorough understanding of your rights and responsibilities, and the establishment of a strong support network. By diligently implementing these strategies, you significantly reduce the risk of facing costly and stressful legal disputes, allowing you to focus on your personal and professional endeavors with greater peace of mind. Remember that proactive engagement and a comprehensive approach to risk management are far more effective than reactive problem solving. The investment of time and resources to learn about and put these measures in place is a small price to pay for protecting yourself from costly and potentially devastating legal problems. By adopting these strategies, individuals and businesses can achieve a higher level of security and stability, both financially and emotionally.
Like and subscribe to support the channel. Donations welcome.